Let's look at some major Supreme Court cases. In 1803, Marbury v. Madison was the first instance in which a law passed by Congress was declared unconstitutional. So it made the idea of judicial review. In 1819, McCulloch v. Maryland upheld the right of Congress to create a Bank of the United States, ruling that it was a power implied but not listed in the Constitution. The case is significant because it advances the doctrine of the implied powers, or a loose interpretation of the Constitution. 1824, in Gibbons v. Ogden, it defined broadly Congress's right to regulate Congress. In 1857, Dred Scott v. Stanford, Dred Scott was a slave who was taken from a slave state to a free state and sued for his freedom. He failed. Roger Taney said that blacks were not a citizen and therefore they couldn't sue in federal court. This would go on to be a major cause of the Civil War. In 1896, Plessy v. Ferguson established the idea of separate but equal, meaning that it was okay for public institutions to separate the races. In 1954, Brown v. Board of Education of Topeka, Kansas said that was wrong, and schools in particular had to desegregate. In 1963's Gideon v. Wainwright, the right for a defendant to have legal counsel, even if he couldn't afford it, was granted. In 1964's New York Times v. Sullivan, the protection offered by the press by the First Amendment was extended. In 1966's Miranda v. Arizona, the right to be told why you're being arrested. At this point in time, there were a lot of people who didn't know all their constitutional rights. And so the decision was made that you had to be informed. And if you aren't informed, you can have a mistrial. In 1973's Roe v. Wade, the decision was made that the court ruled that a woman has the right to an abortion without interference from the government during the first trimester of pregnancy because it's her right to privacy. In 1976, Buckley v. Vallejo, the Senator James Buckley and others challenged a number of the 1974 amendments to the FEC Federal Election Campaign Act, saying the spending and contribution limits on political campaigns violated free speech. They wanted to be able to get as much money as they could from as many people as they could. In 1978's Regents of the University of California v. Bakey, there were limits on affirmative action regarding racial quotas established. 2000, we had Gore v. Bush, or Bush v. Gore. The court reversed the Florida Supreme Court decision ordering manual recount of presidential election ballots. So despite the fact that there was contention over who won the state of Florida, Gore ultimately is going to give up the race and allow Bush to become president. 2003, we had Grutter v. Bollinger, which upheld the University of Michigan Law School's consideration of race and ethnicity in admissions. In 2006, Aota v. Planned Parenthood of Northern New England, a challenge to a New Hampshire law that prohibits doctors from performing an abortion on a minor until 48 hours after a parent has been notified, was heard. In 2007, in Gonzalez v. Carhart, the court no longer requires that the regulation of abortion by government must protect a mother's health. In 2010, in Citizens United versus the Federal Election Commission, the Supreme Court ruled that the government cannot restrict the spending of corporations for political campaigns. 2012, in National Federation of Independent Businesses versus Kathleen Sebelius, Secretary of State of Health and Human Services, the Supreme Court upheld most of Obama's health care laws, so it was determined that Obamacare is constitutional. In 2013, in Shelby County v. Holder, the Supreme Court struck down Section 4 of the Voting Rights Act, which established a formula for Congress to use when determining if a state or voting jurisdiction requires prior approval before changing its voting laws. In 2013 also, in the United States v. Windsor, the Supreme Court ruled that the 1996 Defense of Marriage, or the DOMA Act, was unconstitutional. In 2013 also, in Hollingsworth v. Perry, the Supreme Court ruled that same-sex marriage opponents in California did not have standing to appeal the lower court ruling. And finally, in 2015, in Obergefell versus Hodges, the same-gender marriages were legalized.